The judge indicating that they will go into day 5 of deliberations, but that won't restart tomorrow. There's a scheduling issue, so it will restart on Thursday. Let's bring back in national trial attorney Michael Jaafar, who is watching this with us. And Michael, you watched this trial. We saw the defendant take the stand. We saw the ex-boyfriend, who the defense is pointing the finger at, take the stand. What do you think when you hear the judge say there's movement, or the jury telling the judge we've had some movement today? What could that mean?
I think it can only mean one thing, in my opinion. Everybody is conflicted about this case because you have a situation where the ex-boyfriend who actually had the motive to murder his ex-girlfriend admit to murdering her, right? And then obviously he retracted it, and the defense and the prosecution doesn't believe that anything ties him to it. I call bunk on that in terms of whether or not that is enough compelling evidence to overcome and over-obviate the reasonable doubt against the current defendant, right? So I think that if you're a jury, and I've got to be careful because I've actually practiced in that courtroom, I know that judge, this is bizarre. I've been involved in some of these cases on the other end where somebody had written a confession and then retracted it, but they couldn't, they were in prison for life, and their confession was clearly, troubled. Now you have a situation where, I don't know if I've seen this before, where somebody confessed to murdering somebody they had a motive to murder, and somebody else is on. I'm not saying he did it. I'm just saying that if you're the jury, you're gonna be conflicted before sentencing to life another person who says they didn't do it, who maintains they didn't do it, and maybe he is guilty of only lying to his girlfriend about stealing cars. Maybe that is in fact what happened. But if you're juries, you're going to be conflicted.
Let's go back to those moments, because we had two very important witnesses on the stand. I want to listen back to first the defendant talking about why blood was on his jacket that was from this victim, but he left, didn't call police. But also then that ex-boyfriend who took the stand as well to face that alleged false confession. Let's listen.
Did you attempt to call the police?
My first reaction was to reach for my phone, but I had to consider where I was and what I was doing at the time. And I didn't feel like, me personally, that would be a good idea to call the police. Okay, and when you said you had to consider where you was and what you were doing, just I guess, break that down a little bit. What were you doing in your mind? Well, I was over there breaking into cars. Well, not breaking into cars, but going into motor vehicles. And I felt like if I had to call the police, I would be incriminating myself, because the first question they're gonna ask is, what are you doing over here? I have a history of cars, so I figured I didn't want to be in trouble, and I'm already facing habitual status if in trouble with any more cars. To my knowledge, any new charge with the same crime, I was looking at 25 or more. That's what you thought? Yeah, because I was a third, so a fourth would make me fourth habitual.
I was trying to figure out what had happened. I was trying to rationalize it in my head. That was, there were all kinds of irrational thoughts going through my brain at that time, and I was trying to rationalize what was going on. I had no recollection of killing Sam. That I was thinking, I had convinced myself that I had done this act, but I could recall nothing of it.
Michael, listening back to those two moments from trial, you get a sense of why this jury is struggling, why they keep coming back saying they are deadlocked, can't make a decision on guilt or innocence. But I want to ask you, I know I have to tread lightly because you said you've been in this courtroom before this judge, but I want to get your reaction to the fact that the Allen charge was given. That's the last-ditch effort by the judge, reading it to this jury to say, try your best to come back with a verdict. And then after that Allen charge was given, that's when they swapped out the juror for an alternate juror because of the scheduling conflict. Are you surprised that it wasn't just a mistrial at that point?
No, because this is a Detroit jury, right? And so you have a person who doesn't live in Detroit testifying that he made a mistake by confessing to the murder of his girlfriend, who also doesn't live in Detroit. And then you have a person who does live in Detroit on trial for that murder. These jurors have been lied. The population in Detroit have been lied to multiple times by multiple government agencies, and they're fed up. So I'm telling you the conflict that exists within that jury. I'm not in that jury room, obviously, but I mean, I might as well be by knowing, what's going on. I was a public defender in the city. So like, I know that they did not buy the testimony of the ex-girlfriend. I'm trying to be polite. I'm trying to be, polite about it. They didn't buy it. At least some of them didn't buy it. But obviously the person who's on trial does have a history of breaking into cars. So it's a tough one. They didn't acquit, so obviously some of them believed that he's guilty. Some of them did buy the story of the ex-boyfriend, but there's conflict. I think that judge had to do the Allen charge, Julia, because I don't think any jury is ever going to be unanimous on this case. I'll be straight up. I don't think any jury is going to be unanimous. Not 1, not 2, not 10, not 50.
Yeah, curious to see how things go, because right now they're overextended on the schedule. They told this jury they would already be done, so that's why we're having these scheduling conflicts, because these jurors thought they would be done at this point. We have to get to a break, but first let's bring in national trial attorney Michael Jaafar. Michael Jaafar, this pillow, does that equal sleep? And if sleep, does it make it more or less possible that this is battered spouse syndrome?
Way less possible that this is battered wife spouse syndrome. When we were in law school and we were learning about all the possible defenses that people could have when they, when, hey, it's not a whodunit, I murdered the person, but was there a justification? Self-defense is the easiest one, but battered wife syndrome was one of them. And here's how law professors would explain it so the public can see. It was so difficult to explain that they had to explain it with an example. That's when you know that something is difficult, and they say, hey, here's an example of what it is. And every example every law professor would give you when he's trying to explain to you what complies with battered wife spouse syndrome, they'll say, you've been abusing your spouse for years, verbally and physically, and then one day you look at them, you get off the couch and say, you know what, that's it, I've had enough, I'm going to go into the other room, I'm going to grab a weapon, and I'm going to come back, and I'm going to kill you this time, and this time I mean it. And they get up, and then the other spouse grabs a gun and shoots that person dead. That's the example they give you. If a person is laying down on a couch and is asleep, and you're actually a law enforcement officer, and we know that she was wearing part of her vest at the time of the incident, you premeditated this. So
we will see what the jury does with this case. Michael Jaafar, we have to get to a break. Stay with us. Court TV Live next.
Let me bring in national trial attorney Michael Jaafar. Michael, if you would please weigh in about number one, the judges speaking to the defendant, not unusual, informing them they have the right to testify. Do they understand that? They can claim the privilege. But then he started to go through the sentencing. And do you understand the sentence could be 21 years to life? Was that typical in your experience to go through that with the defendant at pretrial motions?
No. The only time I've seen it is when a defendant waives her right to an attorney and waives her right to a jury trial. That was more like, I've never even seen it when people have a public defender and they waive a jury and they ask for a bench trial. It was very bizarre. And he kept talking about the 3850 motion, which is really for post-conviction, hey, you have the right for this, you have the right for that. And he said, well, I want to be, when her attorney challenged her, he said, well, I want to just make sure that she knows, because later on she's going to bring up all these things and she might bring them up, and I want to just lay a record. Wow, it was too much. It was so much, Judge Ashley, that her attorney had to stand up, felt compelled to say she's satisfied with her choice of counsel. I've already conveyed that to her. And then even after the bizarre train was over, then her attorney stood up and answered another question where the judge said, hey, if she has these questions, she'll actually convey them to me, and then I'll convey them to you. You don't have to have this situation. So there's a place for it, Judge Ashley, but it went too far. It went off the rails, I think, 5 minutes in.
It reminded me a little bit of what a judge might say to a pro se defendant who doesn't have an attorney to make sure they understand everything. So I too felt like it was just a little unusual. Let's ask though about that 911 call where the neighbors saying things like they've been having trouble. I agree with the judge's ruling. He said it's an exception to hearsay. It's the present sense impression. And I agree. I think that the jury has a right to hear all of that under that exception. But as a defense attorney, do you agree or disagree with it?
100% agree that it satisfies many exceptions to the hearsay exception, excited utterance, present sense. So, you know, they have to hear it because, look, Judge Ashley, the charge against her is a proper charge. It's not murder one, it's murder two, right? And you know, so we need to know whether or not there was a crime that came up through self-defense, passion, whatever the case may be. We need to know all of this. So every piece of evidence is relevant. This was not evidence that was prejudicial really against one way or the other. It's just illustrative of the situation because he was hit in the right. There's going to be, you know, expert testimony that he was not hit in the chest until he was turning around, but he did not have a defensive posture. Their theory of the case is that she shot him when he was not aware and when he was not attacking her. So the fact that they were having problems is absolutely relevant and illustrative of the situation. Everything led up to that incident, and we need to know why she would have shot him. We know she shot him. Why did you shoot him?
Yeah.
So I think this is important.
Yeah, I didn't mean to interrupt you, but I completely agree with you, Michael. And I think the defense obviously wanted it in, but I think it also paints the entire picture in a case in which she was saying there was domestic violence battered syndrome in this case. Let's listen together because some of what we know might come up was shared in a custody hearing. So I want to listen to a little bit of some of what was said during that custody hearing.
I was headed towards the laundry room because I was afraid, and he started screaming, and he told me that, this is a quote, that he was going to blow his brains out. And so I stopped and I dropped to the floor and I started crying and I begged him to not shoot the gun. And he said that I was going to have to watch him shoot his brains out.
Listen, Michael, we've had a lot of cases lately and all kinds of cases where the defendant's words are used. And here's yet another example. If she chooses not to testify, they can use this testimony from the custody hearing to impeach her if she does choose to testify. And the alternative, where there'll be opportunity for it to come in if she doesn't testify. I'm putting all that out in front of you because we hear her in her own words in that unrelated hearing.
Absolutely. You as an attorney, so when I used to practice criminal defense law, there was always pretrial hearings before a criminal defense, an actual trial, right? Not every state has it. In Florida, this is perfect because you can actually bring it in. She was sworn, she was under oath. It can absolutely be admitted. Also, what I will say is in custody hearings, Judge Ashley, everybody know, all of us know, people exaggerate and embellish to get their way, right? I'm not saying she was embellishing here. Maybe she was telling the truth. Maybe she was spot on. But we know that that happens. But you have to live with that. When you decide to kill somebody because you feel that you were in fear for your life, it's a split moment. We think it's a split moment. Maybe she premeditated it, but I don't think she did. It's a split moment, but you have to, in that split second, understand that everything you've said and done and emailed and texted and recorded and shot a YouTube video on, every single thing you've ever done will in fact be brought in, could in fact be brought in because the public wants to know. Only she knows whether or not she was doing this in self-defense. Only she knows, and she will die with that information. We're looking to put the pieces together, and a big piece of evidence is this testimony at her custody hearing. It doesn't get better than that in terms of authenticity.
I agree with you completely, and I can't wait to hear more at the trial about everything that does come in and what this jury's going to decide. All right, Michael, you're staying with us. Thank you for that. While they are approaching that bench, a perfect time to bring back in National Trial Attorney Michael Jaafar. Michael, he really summed it up. That was redirect, actually, not cross-examination, but his testimony can be summed up to me in that last statement. Everything is indicative of laying or slightly vertical on the couch by the victim. Now, my question for you is, if that's the case, and we know there was no weapon recovered close to him or on his body, can words be enough? If he were saying things to the defendant student. Could those words have been enough to threaten her life in her mind?
In law school, professors would explain the battered wife syndrome defense with an example. That's how you know it's very difficult to explain when the professor has to give you an example. The example they give you is you've been verbally and physically abusing somebody for years, and then one day you tell them, you know what, I've had enough. I'm fed up. I'm going to go to the other room. I'm going to get a weapon, and I'm going to come back, and I'm going to kill you. That's the example every professor has ever given, right? That's how difficult it is to prove this, right? So if he's just laying on the couch without any weapon and she shot him while he was on the couch, it definitely doesn't fit the example I gave. And now I can kind of see a little bit more clearly why the state brought a murder 1 charge, not a murder 2, because now they can say she premeditated. They clearly spoke to this expert long before, this trial started, and he told them what he just told on the stand, which is he was laying down the whole entire time. He never got up. And she shot him. She basically executed him. And so that's why they came in with a murder 1. At the beginning of this trial, I thought it was an overcharge. I no longer believe it's an overcharge. I'm not saying she's going to get convicted, but yes, Judge Ashley, that is everything. If the jury believes what this expert has said, that this person was laying on the couch, did not get up and got shot in that state, this is the whole entire case.
It is, but the defense might have experts that say the opposite. We often see that. I don't know if they do or not, but let's do this. They are done. We want to get back into court. Here